they are all disqualified. And we, on the same day at 5 p.m., are given a notice. In the meantime, this happened on the 22nd. Before that, on the 21st, the majority faction had already issued a notice for the removal of the deputy speaker. Which was pending. The deputy speaker, my lords, on 25th immediately gives a notice to our faction and says, give your reply against your disqualification, because the allegation is you did not attend the meeting as convened, and because you have not attended the meeting, you stand disqualified under 10 schedule. And gives us 2 days to file our replies. Now, this comes to be challenged on 27th of June 2022. Wherein this honorable court says that as an interim measure, time is granted till 12th of July 2022 to file our replies. Immediately after that, MLA's leader of the opposition meets the governor and asks for a floor test. It is at that stage, and the governor issues a communication to the then chief minister directing him to face a floor test on 30th of June 2022. A writ is filed by Mr. Prabhu, who according to us was illegally appointed as the whip by a minority of the members in the Supreme Court. A direct 32 saying that the governor should be directed not to hold.
A writ under Article 32 by Mr. Prabhu.
Yes, not.
He was a whip since 2019. So
sorry, Mr. Prabhu? What?
He was a whip since 2019.
I said we had removed him, I had said.
Mr. Sunil Prabhu.
Yes, we had removed him on 21st of June. I had said so when I was giving my events. We had removed him and you had removed Mr. Shinde, which we said was a wrongful removal as minority evidence. That's what I said.
Right.
Now, my lords, so they find a direct
32 is by Mr. Prabhu.
That's saying that no floor test should be held.
Yes.
In view of the fact that disqualification of 42 MLAs is pending. Arguments for over 3 hours are held in the matter, and ultimately the court says that, look, in view of the law as laid down, as we cited, the court has said floor test, if at all, should be held at the earliest. And we said, why should you shy away from a floor test? You can't today say because a disqualification is pending, the floor test should not take place, because there are judgments of your lodges to say, even if a disqualification of an MLA is pending, he is allowed to vote in a trust vote. He is allowed to vote on a floor test. He is allowed to vote on the disqualification of a speaker or a deputy speaker. The proceedings and the function of the House cannot be stalled merely because the disqualification is pending. And those are your lordship's judgments on the point, on the issue swearing. And given the fact that floor test is the surest way to determine who actually enjoys the majority in the House, if at all a chief minister is confident enough, he should be more than eager to clear the floor test, rather than evade and escape and run away from a floor test. So the court said, and directly said, we do not find any ground to stay convening of the special session. Now, my lords, immediately after that order comes, on the very same day, that evening, when the order is pronounced,
What's the date of that order?
29th of June 2022.
Yes.
On the same day, Mr. Thackeray resigns as the Chief Minister. Mr. Shinde and Mr. Padnase approach the governor, stake a claim to form the government. Mr. Shinde is sworn in as the Chief Minister. Then after that, the Speaker is appointed. The Speaker proves it because they ultimately again challenge the Speaker's again appointment and Mr. Shinde's appointment. The Speaker is overwhelmingly voted and confidence is reposed. And these are the facts which ultimately led to their all-inclusive one petition which comes to be filed where this IA has. I'm running through some of the other facts which may not be so relevant. So that's the broad background in which they now come up with an all-encompassing writ petition, saying that the decision of the governor to call Mr. Shinde to be sworn in, the floor test, of course, had become infructuous by then because the earlier writ petition, the Chief Minister had resigned. Then they say the Speaker's appointment, etc., all illegal, and the Supreme Court should decide all these issues. Even before the Speaker decides these issues, all of these proceedings should be transferred to the Supreme Court and they should be decided. There is no mention in the prayer clause or the writ petition about the Election Commission. In fact, there are categorical pleadings in the writ petition that the issue of who is the Ship Sena is the exclusive domain of the Election Commission. This is their writ petition, where they say the decision as to who is the Ship Sena is the domain of the Election Commission. Now, after that, my lords, we approached the Election Commission. The Election Commission, looking at the nature of representation that we make, say that clearly there are MLAs on this side, there are MLAs on that side, there are representatives on this side, there are representatives on that side. So obviously a dispute has arisen. And issues them notice to come and file a reply, place the relevant documents before the Election Commission to take a considered decision in the matter.
Mr. Kaul, where did they make this categorical argument that decision should be of?
Yes. Page 8 of our convenience compilation, round D. That petition was filed on 8th of July 2022. But I'll come to the specifics later. So at that stage, when the Election Commission says, come and file the relevant documents before us, we have to proceed as a coordinate constitutional authority and exercise our jurisdiction to see who represents, because this is really an intra-party dispute. No one is saying, our case is not that we voluntarily given up the membership or we are splitting from the party. These are two rival factions within the party. So the EC said, we'll decide as to who represents the Ship Sena. They come to the court and say, the EC should not be allowed to go ahead. The EC says, the Supreme Court says, we are giving you more time to go and seek time from the EC to file the documents. That request is again reiterated later, and the court again extends time to file documents before the EC. There is no order ever injuncted, and there was no notice issued in this IE to EC also. The order is go and seek more time to file documents. No injunction order ever passed. And ultimately, my lords, when your lordship passes the order of reference to a constitution bench, on the same day, an order is passed saying that the issue as raised in this IA will be considered by your lordships. So it is factually incorrect to say that on repeated orders of the Supreme Court, an injunction was being granted, or it was an understanding between the parties that the EC will not proceed with the matter.
Just give me the date on which the Election Commission issued the notice.
Yes, ma'am. 22nd of July, 22nd of July, 2022.
And what is the date of the order of the Supreme Court? No injunction, you said, but only time to file a...
Yes. 4th August, it says grants liberty to the petitioner to apply for extension of time before the election commission.
Yes.
Now, this is the background. And our respectful submission, of course, first is that this IA is beyond the writ petition itself. No substantive petition has been filed.
One short question. The letter of 1st of July 2022 issued by Shiv Sena Secretary for removal of R4, R10, R27 was made to the Election Commission. You will get it 360.
Yes.
So they wrote a letter to the Election Commission saying that we have removed them from the political party. Am I right?
Yes.
Yes.
And
That
even
is prior.
earlier, in June, they had written a letter to the Election Commission informing that they had taken the decision there. And
Not expelled from the party, removed from the post.
Correct.
Just not.
Removed from post.
Position, removed from the position of
Thank-
leader in the party setup.
my lord, so all that I'm saying is, and I'll now summarize what my points in the law is. The law today is laid down by your lordships on a number of these issues as sought to be now canvassed is no longer essential. One is, my lords, your lordships have categorically held that the jurisdiction of the speaker, when examined under the 10th schedule, is to exercise his power to determine disqualification in the House. The Speaker cannot embark upon, those are the words used by the Supreme Court, the Speaker cannot embark upon deciding a split or a merger within a political party. Secondly, what your lordships have held is that
Except with one caveat, Mr. Kaur, that the whole concept of a split now is alien to the 10th schedule. That's one. Therefore, the reason why the speaker can't decide as to whether there was a split is because the 10th schedule now obliterates this concept, effaces the concept of a split. On merger, perhaps you may not be right because merger is expressly a defense under the 10th schedule, under clause 4. Therefore, whether there has been a merger or otherwise may possibly fall within the ambit of the split.
I'll show some of the other provisions also which
Right.
still be in the context of the legislature party, not the
That point you have made. That is
My
all
lord,
the concept.
my lord, your lordships were absolutely right in what your lordships are saying. My submission on merger is only that the speaker's jurisdiction is on the legislature part. That part of subclause 4 of 10th schedule was not read out to your lordships. I'll just read that. Secondly, my lords, your lordships have held that even where the symbols order does not predicate a particular situation or deal with a particular situation, the Election Commission of India, exercising its expansive and the words used are plenitude of plenary powers under Article 324 of the Constitution, is well within its rights to deal with any situation that arises. That is not to say for a minute that I am canvassing that under clause 15 or clause 80 of the symbols order, the Election Commission does not have the adequate power to deal with the situation like that. I'm going a step forward. Even in 15 and 18 were inadequate to deal with the situation that we are dealing with. Your Lordship has said the plenary powers are enough for the Election Commission to deal with any such situation. But here, categorically, 15 deals with two rival factions within the party. And 18 covers situations which the Supreme Court has interpreted as interim directions or other orders which may be passed in the interest of justice. And your Lordships in Sadiq Ali, while in detail dealing with the symbols order, categorically first dealt with the issue that a situation arises of two rival factions within a party. 15 is squarely the provision which sufficiently empowers the Election Commission of India to deal with it. And then Sadiq Ali proceeded to say that while considering it, both the legislative majority and the political majority will be looked at. But that is the Election Commission of India. A constitution bench of this court has already said that while the speaker decides the 10th issue, 10th schedule, jurisdiction of disqualification, he can't get into the political party because the very nature of the dispute is such, as my lords pointed out today at the start of the hearing, 1.5 lakh, 50 lakh representation by us. Zilla Pramukhs, Talukas, district officers. Evidence is there. The powers, as your lordship knows, have been vested, and the power, and the Supreme Court has said powers of the state, powers of the court on the Election Commission of India. That is the alternative adjudicatory machinery created to deal with each of these issues.
Only thing, Mr. Paul, the genesis of the entire dispute, I think that's really the sense of the submission, that the genesis of the entire disputes arises from what happens on the floor of the House. Right? Absent what happens on the floor of the House, everything else wouldn't have taken place. That's their contention. Now, if that is so, then the issue as to what happens, the symbols order predates the 10th schedule. Sadiq Ali predates the 10th schedule. Right? Because Sadiq Ali, in fact, Justice Hegde Grover and Justice Khanna.
That's right.
Now, Sadiq Ali predates the 10th schedule. Therefore, when Sadiq Ali speaks of the powers of the EC to determine both the legislative and the organizational majority, that the former part, namely its authority to decide the legislative majority, was at a time when the 10th schedule was not in operation. Now, does the fact that the determination of whether or not a disqualification has taken place is now exclusively entrusted to the Speaker, does that to that extent dilute the authority of the EC? And if so, then what is the impact of that decision which is entrusted to the Speaker? That is, I think, what they were really driving at.
So, my lords, firstly, post Sadiq Ali also, and I'll show those judgments if required. There have been judgments.
No, we've seen those judgments. We just formulate the point.
Post Sadiq Ali also, which have talked about the interplay of 10th schedule, symbols order. There is nothing to suggest. There is nothing to suggest that any way does the 10th schedule dilute the exercise of jurisdiction under the symbols order 1. We, my lords, the constitution bench of this court, categorically says that when you embark upon this inquiry, it is restricted to majority in the House. Because the very nature of inquiry that we are talking about, where a political party is completely beyond the machinery provided for the Speaker or the powers vested in the Speaker. And that is why that whole line of judgments, my lord, where your lordship said powers of the state, powers of the court, all vested in the Election Commission of India. Detailed evidence. Now, will the Speaker get into interacting with every taluka pramukh, every district officer, every president of every area, the registered membership of the party? It doesn't get into all that. There is no machinery for it. That's not the intent. And if your lordship sees everywhere in the 10th schedule, political party in a context and then followed by legislature party, as your lordship pointed out, including clause 4 of 10th schedule. And it is interpreting that a constitution bench of this court says that when you embark upon the journey of deciding on disqualification from a house, don't mistake this for a power to decide the larger political issue or division in the political party, which is there. And I tell your lordship, because inherently it can't be done by the speaker. And there is nothing today in this matter, my lords, nothing at all as far as the pending petitions are concerned, whose outcome in any way will impact what is pending before the Election Commission of India. I take their case at the highest, that we will all be disqualified as members of the House. I take their case, that's the maximum that can happen, my lords, that we are disqualified as members of the House. Does that stop us? Does that stop us from going to the Election Commission as a member of a political party to claim that we represent or we are the Shiv Sena?
But suppose you were to argue on a demurrer, assume for a moment that the person who has moved the EC is disqualified. All right, for a moment on a demurrer. Does that disqualification of the person who has moved the EC impact upon either his locus or the authority of the EC to determine who really represents, which of the two factions represents the party?
So Mara, that's a very pertinent question. Let me So, my lords, the question that my lords put to me, let me give your lordships two stages which can answer. One is what is happening here, and the other is what your lordships put. One is that disqualification petitions are pending. The Supreme Court has told the Speaker on their request not to, in the meantime, take any decision on those because the Supreme Court was seized of the matter, as far as the Speaker's exercise of jurisdiction is concerned. And pending those petitions for disqualification, can an MLA or an MP be prohibited from approaching the Election Commission? Your lordships in any number of judgments have said that even when disqualification petitions are pending, an MLA and an MP is well within his rights to participate on the proceedings of the House. Vote, exercise all that is vested in and under the Constitution.
So until he is disqualified, the consequences don't attach at all.
Absolutely,
that's the rationale for it.
One, and including my lords.
Yes.
including the line of reasoning that your lordships took
Yes.
in Navam Revia, that
Yes.
if a deputy speaker or a speaker of membership, that he can always proceed in a direction where his own disqualification, that was another lane, would be accordingly impacted. So till I am disqualified, I continue to be a member to participate all its vigor and robustness in the proceedings of the House.
At page 359, that very question. This is a letter written by Uddhav Thackeray to Eknath Shinde saying that you have been indulging in anti-party activities and have also voluntarily given up your membership in Shiv Sena. Therefore, in exercise of powers vested in me as the Shiv Sena Paksh Pramukh, I remove you from the post of Shiv Sena leader in the party organization. So this doesn't affect his primary membership. As if his primary membership is actually affected, then he can't maintain a petition before the election commission. That's perhaps their argument.
Yes.
So therefore, at the threshold, election commission cannot maintain a petition on his behalf. But it is not affecting the primary membership. It is only a post he continues to be a member of the political party, then he can perhaps file.
And my lord, just to add to what your lordships are saying, this is their contention that I have given up. My whole case is who says I have given up the membership voluntarily.
That is yet to be considered.
That is yet to be considered. My whole case is that a set of 14 MLAs decide that I am removing something and overwhelming majority is on one side. You take a unilateral decision with a hopeless minority and then say, I've disqualified you or you voluntarily given up a membership. We have repeatedly said that we are the Shiv Sena, whether it's in the Lok Sabha or it's at the Legislative Assembly. We represent an overwhelming majority within the party. We've never said we've left the party or we need to merge with someone under 4 to be protected. We have right through said that whatever actions a set of people who are in a hopeless minority took have no sanctity of law, are unsupported by any legal provision at all, and you could not have done, you did it without authority. So with such emphaticness, when it is said that you voluntarily gave up the membership of the party, who will decide this? Because you say I've given up voluntarily the member under 10 schedule, or will the speaker decide it under the 10 schedule? Because your lordships have held that the power of the speaker and the decision of the speaker under clause 6 of the 10th schedule is final on these matters. And that decision is still pending. My lords, was the question that your lordships put to me, that suppose a person, now this is the first stage where no decision has been taken, the issue is pending. The other is I am actually disqualified and I incur the wrath of Schedule 10 of the Constitution by whatever action there's a decision of the speaker against. That still does not, as my lord said, deny me the primary membership of the political party. I'm still entitled to approach the election commission for whatever grievances I may.
That you have said, so that you are not removed as a member of
Yes.
the party. You may be removed, correct, disqualified as a member of the legislative party.
And now, my lords, they sought to rely on Sadiq Ali to say that, look, both the words legislative and organizational majority have been referred to in Sadiq Ali. Now, organizational and legislative majority is referred to in Sadiq Ali from the perspective of the EC deciding, not from the perspective of the speaker embarking on an inquiry as to who represents a majority in the political party. Then they relied, my lords, on to say that this will have a bearing on the matter because a judgment of this court said, and I'll read out in what context the judgment was when I come to the case law, to say that any disqualification ex post facto relates back to the date when you were disqualified. And thus, if they were disqualified on that date, that's the end of the matter. Quite apart from the fact that even if I was disqualified, it doesn't stop me from going to the EC. But the reason the Supreme Court said ex post facto, and there are other paras that I need to show, was this. That was a case of a BSP government in Uttar Pradesh. A decision was taken to dissolve the assembly. The cabinet decision was yet to be communicated. I'm just very briefly giving. 13 MLAs of the BSP went to the Samajwadi Party and said, stake a claim to form the government. Because these 13 MLAs went to the Samajwadi side to stake a government, Mr. Maurya at that stage made a petition to the speaker saying that this is an overt act on part of 13 MLAs to show that they have voluntarily given up the membership of the party and thus they ought to be disqualified. So the speaker was seized of this issue of disqualification of MLAs as on that date because 13 MLAs had gone to the Samajwadi party side. In the meantime, another 24 MLAs joined the 13 MLAs and they claimed that there has been a split in the party. Now the speaker went ahead and decided the issue of a legitimate slip with 24 joining 13 and did not decide the issue of disqualification, which Mr. Maurya prior in time had directed, saying that your very act of going and seeking support from the Samajwadi party amounts to giving up an anti-party activity, voluntarily giving up membership. In that context, the Supreme Court said as far as exercise of powers by the speaker is concerned, as this disqualification will relate back to the date when the speaker was required to exercise the jurisdiction and the speaker could not have decided on the split within a party without deciding their original disqualification from the house, which stood there. It is in that context that the word ex post facto was used. And I'll show those two specific paras. The same judgment, my lords, the Supreme Court then goes on to say that you as the speaker can't embark upon and decide within a political party what happens. Your lens is only the lens of a legislature party that you have to see it. And inherently, my lord, the proposition which is sought to be forwarded will be impossible to implement. A, the constitution doesn't say so. B, practically and inherently, it's impossible if you expect the speaker to get into these issues of lakhs and lakhs of memberships across the country without the necessary adjudicatory machinery.
So according to you, both the powers are different. Jurisdiction under both the powers are different. Correct, and the inquiry under both are different.
Completely different. If at all, my lords, if at all, a finding of the EC may help speaker, if at all, but nothing that the speaker decides will ever impact a member approaching the election commission. So to say that the two petitions are intertwined, thus this must await the decision in the main matter, is completely wrong. Now, my lords, even as far as that one question which is referred to, which is the last question, J, which I just...
Scope of powers of the EC with respect
My lords,
to determining.
all that is, I'm very clear. What is the scope of powers of the Election Commission of India with respect to determination of a split within a party? No one has questioned the vires of the symbols order has already been upheld by your lordships. No one has ever questioned the power of the Election Commission. All that has been said herein is the scope of the powers of the Election Commission. Now, if I were to accept the argument as sought to be forwarded by the petitioners, my lords, then till the Constitution bench of this court decides on the scope of powers of the Election Commission, this may be the Shinde versus Thakre matter, but there could be another matter where there are disqualifications of MLAs and another set of people go to the Election Commission. So the Election Commission is denuded of its powers as a coordinate constitutional authority to continue and do what it is mandated under the Constitution to do, because your lordships are seized of the question of the scope of the Election Commission. This is one matter, my lords. All that has been said, court in its wisdom thought that the scope of the powers needs to be looked into. My respectful submission would be, my lords, even the scope of the powers divorce the symbols order in the light of judgment of your lordships is expansive and plenary. But the symbols order itself under clause 15 and 18 specifically provides for a situation like ours, which is rival factions within a party, interim directions to be given. And my lords, your lordships in any number of judgments again have held that pendency of disputes does not bar the Election Commission from issuing any interim direction which it feels is necessary in the interest of justice in the meantime. Now, another argument raised was, what happens if the Election Commission suddenly freezes the symbol? Who will be able to contest? There will be mayhem, there will be chaos. What will happen? Now, my lords, your lordships have also held that you are entitled, if you represent the overwhelming majority, whatever you think you represent the overwhelming majority within the party, to go and say that we are entitled to represent the party and use the symbol. That's your legal right. Symbol is otherwise not the property of an MLA. It's the decision of the Election Commission. But I have a legal right to claim that I can use it. That's one that I can do in this matter. Presuming, suppose a situation were to arise in the court and the Election Commission was to come to a conclusion, no, we can't decide. There are orders, there are freezing orders that have been passed by Election Commission, and in the intervening period, temporary symbols have been given. Those are not jurisdictions of Election Commission to decide. You today in a 32 want the court to be seized of the matter, exercise the jurisdiction of the speaker as a court of first instance, exercise the powers of an Election Commission under a 32, and none of these constitutional bodies should be.
Yes,
My lords, I have two judgments to show to one.
Which are those judgments?
One is, my lords, the Rana judgment. Other is Sadiq Ali, and third is Pananis.
So we give you about 5 minutes after lunch.
Yes. My lords, just
yes. On the days, my lord, the Chief Justice indicated on the days when the Constitution bench sits, the Constitution bench runs for the whole day. So we continue.
We'll continue.
Yes. My lords, I just require 15 minutes from your lord because I need to show 3 judgments and some provisions.
Indulgence, a brief supplement by me and Mr. Singh.
10
10 minutes each.
Right after Mr.
Paul finishes.
After Mr. Paul finishes,
Yes, sir.
maybe 5 or 10 minutes,
10 minutes,
between the two of you,
By
and
the
then
call.
we want to hear Mr. Dada
Yes,
because
yes.
he's preparing for a constitution body.
Most important.
Question number F.
Yes,
Or the referred questions. Question number F is what is the scope of the election commission?
that's
J.
J. We'd like to hear Mr. Dada. We do, of course, since we are appearing for party, we hear on this side as well. But we want to hear Mr. Dada.
Yes, my lords, I'll finish with it. Very